Okay, we're going to move right on to our dynamic speaker today. Gary Rauka provides legal representation in the area of commercial contracts, formation, buy, sell, governance, and compliance. His clients include medical doctors and independently owned healthcare sector companies, including home health and pharmacy. Gary focuses on commercial transaction and does not litigate. He's a sole practitioner in Beverly Hills. Gary also provides pro bono services for low-income clients as part of the legal clinic at the Los Angeles LGBT Center, and he is the outstanding moderator of the Century City 10 meeting. Please give a warm 10 welcome to Gary Rotkop, and then mute yourself. If you put it on speaker view, you can see him.
Thank you, Howard. Very, very kind words. I trying to wipe the smug smile off my face, but can't do it, Howard. Thank you again. Ladies, gentlemen, it is an honor to lead this discussion today. A couple points of business before we get started. One, it's a discussion. I've kind of designed it so I can make some points, and I would love to have you participate, weigh in, and I think we will all be that much richer for it, and it'll make for a more enjoyable presentation. So if at any time, just feel free to unmute yourself, go ahead and answer your piece, make a comment, make your question, and we'll continue. So that's fine. I really very much welcome it. Can't stress that enough. Number two, see, everyone knows the trick. If you need to get up or do something super distracting in front of the camera, just turn off your camera, which is great. I think everyone knows. For speakers, once you see like half the screens go black, it's a little bit discouraging. So do this instead. Take a real quick picture of yourself, make it look very professional, and maybe even interested. And then just set as your background, and off you go for a 20-minute, bathroom break, whatever you want to do. So do that instead. Off we go. Upgrading your business deals during crisis. And so I want to address a couple things. Firstly, how are vendor and customer obligations affected by the pandemic? That's what a lot of my clients are asking me. But I think what they really need to know is, what can they do right now to mitigate their business interruption? And I've combined that a little bit with whether you will be ready to continue operations when restrictions are finally lifted. So how's the business deal affected? I think you've got to ask a threshold question. One, is the contract creating a material strain on your business? So there's people out there, and you've met them, that will do a handshake deal, sign a contract. The next day, you're waiting for them to perform or pay, and they're ready to negotiate. Okay, this is not what I'm talking about. So perhaps upgrading the business deal is a little bit misleading. We're talking about making changes because a lot of us are in survival mode. So changes that are absolutely necessary to the core financial strength of your company. The other situation is, do you have an enforceable writing that's consistent with your expectations? So a lot of times, and of course the litigators know this, I think it's the source of nearly all litigation. You have a deal in place, one side thinks it's one thing, another side thinks another thing. Anyone care to share a quick experience, anecdote about how that's happened? Any litigators out there, or any other attorneys? And I'm talking about you have a client enter a deal with the other side, and they're thinking it's one thing. The expectations of the other side are completely different. Anyone want to chime in? Anyone at all? Wendy?
Yeah,
Gary,
unmute
yourself and go ahead. I'm happy to take one or two quick anecdotes.
Yeah, Gary, you basically described every litigation, every contract litigation that exists.
Anything you're working on presently that you want to share?
There's a lot of stuff that I'm working on through in mediations that I can't discuss
Mhm.
But it's basically people enter into contracts and they have different idea of what the contract is.
I'll tell you one, Gary. I'm working on the appeal right now in a case my partners tried
Mhm.
called Underwood versus, or it's called Hoi Fong Foods versus Underwood. It's the hot sauce dispute. Our clients grew peppers for Hoi Fong, who made sriracha sauce, the familiar one that everybody has in their refrigerator,
The
for
rooster.
many, many years. And there was a big dispute about the 2017 contract or lack of contract or ongoing contract. It ended up with a $23 million verdict in favor of our clients that we're now defending on appeal.
Wendy?
Yeah, I'm sorry, the dispute was over.
Yeah.
What were the terms of the contract, if there was a contract at all? And whether they'd been working based on the same arrangements they'd had the past 17 years, whether they did make or did not make a specific contract for 2017. The jury found there was a contract. The jury found both contracts. And one of the arguments that Hoi Fong is making on appeal is that you can't have two contracts about the same thing at the same time. And our position, among others, is, of course, that one contract was just a part of a more ongoing, broader contract. The $23 million consisted of $13 million of compensatory damages, and because we also had a fraud claim, $10 million of punitives.
Thank you for sharing, Wendy. So that's a great example. I think all these conflicts are great examples of what's happened in the past. You have a certain percentage of deals where people just didn't see eye to eye, and that's going to litigation. But that was when at least the basis for their understandings was the same. And now we've had some really kind of earth-shattering moves. So some of the implications, some of the fundamental ideas that were the contracts and deals were based on, they've kind of been shaken. And so when do we resume? What are our prices now? What's going on? How are we going to proceed? I'm going to stress communication, how we can deal with that going forward to prevent and limit litigation. So have the circumstances changed during the outbreak? As you know, the cost of goods, cost of labor, prices for commodities, raw materials, they have changed. Some raw materials are just not readily available anymore. So one thing you can consider, instead of if you need to adjust your pricing or adjust the term of deal, instead of pulling a price or an arrangement just out of air, there are aggregators. For instance, SRS Acquium does a market terms recap, and you could look to what the terms are for a particular type of deal, whether it's an M&A or another type of transaction. Look to the Fed, look to some sort of objectively verifiable peg that you're going to rely on for pricing or whatever else, if you're willing to adjust it. So you're not going to, once you're opening up, you want to go back to business, you have something that's kind of straightforward that you can apply. So one other thing to consider, how has the balance of power shifted due to the outbreak? In many areas, and LA is not, the hot commercial zones in LA are not as strictly affected right now, but in many other areas, the renters and landlords, is it the landlord's market anymore? Maybe the renter has more of a say. And that's something certainly to consider when the opposing side comes to you and wants to renegotiate the contract. And I do not mean this in the sense, and I have a note here, no browbeating, right? That's not something you want to use abusively as a sword, but something you might want to use as a last resort to stay in business. And that might be better for the landlord if the tenant comes to them and says, hey, we need to work on this if we're going to stay in this. The anchor store that we relied on is gone, and we're going to have a hard time paying this rent. Do you want that trouble, or do you want to take a haircut for 10%? And that might make sense. So that brings us to an example. I thought a lease is a good example because many lawyers I've talked to are considering, is rent still due? Do I still have to do that? I'm working from home. So I've got a commercial lease. There's nobody at the office. How's that fair? So let's look at the lease terms. Most triple net leases, and pulled this out of a triple net lease, say renter is obligated to pay rent without abatement, without set off or deduction. So pretty clear there that this sort of thing specifically hasn't been anticipated, but that would be covered under this. Rent's still due. What about force majeure? A lot of people calling in saying force majeure, don't we all get a freeze? Well, a lot of contracts specifically say events of force majeure do not curtail a tenant's obligation to pay rent. Very explicit. Even without it, traditionally, force majeure clauses curtail performance obligations, right? Not payment obligations, unfortunately. There is something, though, about go dark and co-tenancy provisions. So a lot of companies are told not to continue operations, but the lease agreements require you to continue business. So if you're not planning to reopen when your sort of business is allowed to open, perhaps you're in breach of your contract even as you continue to pay lease if you're shuttered up and you're not operating. So a go dark provision allows you to continue paying rent, but at least you're not in breach for closing your doors while you're trying to reassemble. However, if you have a go dark and a co-tenancy provision, in that case, maybe you can get out of the contract. So perhaps the situation is the anchor store is gone from your strip mall, and you relied on that for 80% of your business. That's in your contract.
Gary, could you clarify? Are you saying there's some clauses in leases that say if you're ever going to stop business, even if you pay rent, you're in violation? Is that what it says?
That is typical. Yes. Landlords do not want to have even kind of the appearance of shuttered businesses in their plaza. So they have in actually very many, majority I would say, leases that I've looked at for my clients, it will stipulate that you've got to keep operations going. That's a separate actionable claim, right? And if you, in fact, you would go out of the way to permit that, and that would be called a go dark provision, saying that, again, this doesn't allow you to get out of the lease, doesn't allow you to set off payments. You have to continue paying lease, but you're allowed to temporarily go dark. Most of those have caveats too that allow the landlord to recapture the lease and sublease it to somebody else. Landlords just don't want to have large parts of their properties going fallow. That doesn't exactly attract other tenants. So they're very concerned about that. From the tenant's point of view, for commercial tenants, if you have that go dark provision and especially a co-tenancy provision, that together might enable you to say, look, I'm no longer able to be here and terminate, and under whatever permitted termination that's triggered because the anchor store that you relied on for 80% of your business is gone from that mall. And that leads us to a second really major point is avoiding business interruptions. And I think the goal is not to profit right now again. The goal is continuity and ensuring vendor-client relations. So a large part of that is communication. A large part of that is communicating about the right things and about your expectations. So even though the goal is ensuring strong relations, sometimes it is a zero-sum game and you've got to stay open. So perhaps it's time to renegotiate the pricing, the delivery times for goods, services, your quantities, risk of shipment, restart time after the crisis, right? So you have a force majeure clause. But back to that. The language usually says you shall use reasonable efforts to resume performance as soon as practicable. Well, there's a lot of kind of vague terminology there, and this is fairly standard language. So what are the expectations? My suggestion is look at your vital contracts and look to the force majeure clauses and reach out to the other side, say, hey, let's replace this term, reasonable time. We're gonna start delivering, and either require a meet and confirm if you just don't have enough information. So agree to negotiate in the future, but have something in writing about that. And that way you're definitely on the radar of the other side. Alternatively, have a specific deadline. So for me, reasonable might be an expectation that you've got your employees lined up when it's time to open, and you've got all your raw materials you need to do whatever you need to do, and I'm going to be getting deliverables as soon as those things can be assembled. On your end, your people might be out to lunch. You may have done some layoffs, and you need to rehire staff, and also whatever materials they're out somewhere. You might be out to lunch, who knows, but we need to make sure we're on the same page. So to that end, I'd focus on bottlenecks. So I would think about really targeting any bottleneck suppliers, for instance, and reaching out to them before they come to me. And I would offer an incentive. I straight up offer them more cash to be the first in line to receive vital services, goods, materials. So look at the supply chains here. We've got labs and reagents for testing, right? You've got a limited source of materials you absolutely need to do the COVID tests. If I was operating a lab, all other restrictions being aside, and let's not talk about anti-kickback rules and whatnot, but I would go to my suppliers and say, what does it take to get me first in line? I will pay you 10% over. This is small marginal cost for me, but if I don't have this material, I can't be in business. So again, focus on the bottlenecks and communicate to clarify. So you want to reach out and make sure you're on the same page. Once you have that conversation, you want to do that in writing. If you've got real concerns about whether performance is going to be timely, or maybe the financial stability of your partners in the joint venture, or whatever's going on, reach out to the other side. Request. You have a right to request written assurances, and that could come in many forms, and that's pretty open-ended. So you can go and say, hey, can you give me some financial statements? I'm a little bit concerned that this is going to happen over the next 6 months. I want to make sure you're on solid footing. That does need to be provided to you in a reasonable time, whether you have that in the contract or you're just concerned about performance under the contract. So I want to open it up and get your anecdotes also. Has anyone had to request written assurances, either lately or during the crisis or recently?
I don't know if you quite about written assurances, but I represent a lot of people that have a lot of real estate, and one of the transactions, one of my clients just acquired a Red Lobster in Texas. Didn't even get the first rent payment, and the pandemic broke out,
Yeah.
and that's an issue. And Red Lobster has 700 locations, and they're coming back and they're saying, we want a 25% abatement of CAM and base rent, and that we will, but we'll continue to pay the property taxes. And since we have Red Lobster corporate on the hook on this particular lease, I wasn't anticipating when we did the transaction, because the client really wanted it, a pandemic. And now we have a situation where they're threatening, which is the one subject you haven't addressed, and that is, well, if you don't like it, we'll just file a Chapter 11 and renegotiate the lease in bankruptcy. And that,
We'll get there. Yeah.
and they say, and by the way, this we can get rid of a lot of our dead weight at the same time. And my response was, well, this is one of your flagship locations, which it is. And so you're going to file a bankruptcy over that. So we're going back and forth. As to your other point, the communication, many years ago, and when I tell you who the parties are, you'll know. I represented a little company called Marubeni, which was a finance arm for Nissan. And there was a communication problem between the purchasers of the vehicles and they're speaking different languages, though the contract was in English, and Nissan, and had to do with delivery, and it had to do with timing and everything else. And long story short, they waited too long. They were bickering, and the state of California came in and assessed property taxes on thousands of vehicles sitting in the port, and that became so also when you're dealing with clients that have different base languages, you need to be really careful that everybody understands the terms of the agreement. And a lot of times, they're coming from out of the country, they're relying on their local attorneys, California or New York or whatever, and the language barriers create incredible problems in who understands the contract. I'm done.
Thank you for sharing.
You're welcome.
Yeah, and I've got another example about written assurances, where you really should use this properly. Don't use it like a sword. I'm representing a client who had a restaurant chain idea, and as he started off with his partner, they brought on an investor. They have Japanese connections. The investor is Japanese, and that's sort of important, and to highlight, the base understandings and cultural understandings should be in line as well. And so the investor put in the first $500,000 in investment to get things moving. The second $500,000 was due. He wasn't timely with that, although specifics weren't well defined in the contract. But he was needing, basically he needed to move some items around to allow some liquidity and get the second payment out. So my client knows the investor and brought him in. My client's partner, a working partner in the States, was getting fed up with the investor not paying. So he went around the person that brought in the investor and wrote a letter demanding payment, asking for written assurances, all sorts of other things. And really, while the investor was liquidating assets to try and make this happen, looked at this, saw that the partners are not really on the same page, and said, okay, now I'm really actually going to hold off on this investment because you guys need to get your stuff together. Do you know what I mean? Because this very nasty letter writing shouldn't be going on. So part of that is a cultural thing. Make of that what you will, and part of that is really shooting yourself in the foot. So use the written assurances properly. It's meant to be used where you really need to know whether performance is going to be timely. and that depends on the financial standing of your partners. And then, you know, if you really need it, then that's what you use it, and it's a very useful tool. But be civil about it. Yeah, anybody have any examples where you have you might have an issue getting some supplies when the reopening begins? We're talking about bottleneck issues.
I'll have a quick story, personal one. My 9-year-old wanted these specific candies that were made famous on TikTok. There's some fruit jellies that are manufactured in Japan. Ordered them in January, and they're all the rage, all the craze. You can get them at dollar stores, but they were selling out everywhere. You couldn't find them. So I went to this company that was based, I think, on the East Coast, and bought 10 bags of these candies. Again, in January. 2 weeks ago, still not here. And I'd called and, issues with COVID-19, this and that. Turns out the actual the manufacturer is in Azusa, even though I was getting it from a distributor in Florida. And they were blaming each other for production issues, logistical issues. Well, I finally just got a little nasty with the people I order from. And I was like, listen, this doesn't make sense. They're telling me one thing, they're telling me another. And within a week, I got the 10 bags. So not directly on point to your question, but what I wanted to share is sometimes a little bit of elbow grease, even when people are claiming that there's logistics, bottleneck issues, oftentimes there will be inventory somewhere. There will be products somewhere.
Yes.
And it's allocated, it's earmarked, and the squeaky wheel sometimes gets that grease.
Yes, that's the point. So you got to communicate your needs to sometimes give that human element. But yeah, the squeaky wheel, that's a really great example. Howard, I've got maybe 2 minutes or 3, something like that, and we'll.
Okay, just.
Is that right? I'll
No, you can, if you have more to say, we have time, so.
I make these modular, so feel free to cut me off whenever. I'll take maybe 3 to 5 more minutes.
If you,
Wrap
that's
it up,
fine.
putting some bite into the contracts, and we'll make sure everyone gets out of here on time so they can maybe get some work done. So let's talk about putting some bite.
Oh, Richard Weissman had something to say.
Oh yeah, Richard, go ahead.
I'm running a dental medical practice, and one of our problems is they cannot function without the personal protection equipment, and they are only doing emergencies because the county dental association or state has said no general dentistry and no general surgeries unless it's an emergency. So this guy does implants and facial surgery on an emergency basis at the moment, and we can't get the PPE based on the suppliers that they use are all backlogged. And I heard the comment, try to find other suppliers, but this one practice is competing against state and federal demands. And so our pipeline is stuck, and Roto-Rooter won't fix it. And I think Robert Borski mentioned there were gold or silver bars in the drainage of a client that he had in a case years ago, and I've got none of that. I got sludge. So I just wanted to note that the supply chain problem is not easily resolved, and I didn't mean to suggest, Gary, that it's easily resolved, but we do have bottlenecks and backups, and then people can't get emergency processes through the smaller professionals, smaller base professionals.
No,
Yeah.
but when there's a will, there's a way. If you really need something, you need to act on it. Don't expect right now to be business as usual. There's a lot of interesting stories out there. I don't want to spread rumors about the Mossad of the Israeli government maybe redirecting some shipments of vital supplies from ports. maybe desperate times, right? That's something that they identified as a need, and somebody's going to get that supplies. So what are you going to do to get it? Now, I'm not saying you should break laws or get involved in, international fatwas, but maybe you've got to do something, right? Pick up a phone, but maybe something more. Not throw money at the problem, but maybe offer some incentives. Okay. Let's talk about making enforceable changes and generally putting enforceable language into contracts. So what I think is best is a practical, enforceable, clear, verifiable mechanisms. The phrase I use is good fences make good neighbors. And I always apply that to contracts, right? If you know what your lane is, what's expected of you, clearly, when you have an issue, you look to the contract, and that debate doesn't turn into something extreme. There's no work stoppage. There doesn't need to be a lawsuit. You're basically done because you have the contract, and hopefully you can move on and go back to business.
Gary, Steve Marcus had his hand up.
Yeah.
Yes.
There is a legal doctrine called frustration of purpose,
Yes.
where because of circumstances beyond the control of either party, it becomes impossible for one party to the contract to perform. And while it's not a breach of contract and it doesn't avoid the contract, in certain circumstances, it can be invoked to eliminate any future obligations of the parties under the contract. In other words, to cancel the contract because it has become impossible to perform.
Absolutely.
Have you come across that, Gary? And
that is something. So I try to avoid the technicalities and getting into the weeds. Of course, even you're aware of the technical arguments, the legal arguments that we make, but you can certainly use frustration or impossibility as a defense, right? The old law school example, you pay somebody to paint the house, they show up, they want payment, and you say, well, sorry, the house burned down. We can't go on. So maybe both parties are excused in that case. Yeah, so you have some situations where, again, the fundamental understandings that the contracts are built on maybe have moved to such a degree that the contract doesn't make sense. And that's when we call to renegotiate the terms of the contract. Oftentimes, that's the argument in a practical sense, right? Sorry, but you wouldn't be able to enforce this contract because we can use this defense. But thank you for explaining that, Stephen. It's much appreciated. So back to putting some bite into the contracts. And so if you know what's expected of you, they know what's expected of them, you have a better likelihood of getting performance, getting through this deal, getting through this transaction without any surprises. But what I want to stress is look to the deal. Don't just think about it, review it, and does it still make sense today? And really get into the shoes of the other side. Does it make sense from their point of view? Does it make financial sense? Does it make practical sense to carry out the deal? You may not be anticipating this, some sort of work stoppage or something like that from the other side, but the deal no longer makes sense to them. So address that before it becomes an issue. If you have a performance where timing is important, and nearly always I think it is, you want to put a time is of the essence language, a clause in the contract that says specifically that time is of the essence. We need to get this done when it's due. And that might entitle you to more leverage if it comes time to negotiation. Liquidated damage provisions. Remember, these can't be punitive. We need to make these make sense. But if push comes to shove, you're threatening litigation. If you go to litigation, you might be able to save costs, for instance, on proving up damages. And that gives you, again, much better leverage in negotiations outside or pre-litigation. Stipulations. You can stipulate to things. You can limit causes of action. You can do a lot of things in commercial contracts as long as they're done properly and in good faith, and you're on the same page. You can do a lot of this to give you better leverage if you're anticipating a problem. Now, if the other side isn't willing to put certain stipulations or add specificity as far as delivery timelines, things like that, that too is telling. So it's not like you've reached out and gotten nowhere. You've actually gotten some information that says maybe you want to have a backup plan. So I want to wrap up by repeating, I think, the goal, or putting the goal like this. Work to what is a mutually satisfactory business solution, one that doesn't place a great financial strain long-term on either party. So thank you so much for staying tuned. I cycled through, and everyone's either like here for the most part or took great pictures themselves, even looks like they're moving a little bit. So thank you for hanging in there. I hope you enjoyed it. If you did, tell your moderators about me. I'm available for bar mitzvahs, and yeah.
Thank you very much, Gary. We really appreciate it.